I knew something was wrong the moment I pulled into my driveway and saw Patricia Henderson standing on my front lawn with her arms crossed. Her face twisted into that particular expression of righteous fury that only HOA board presidents seem to master. It was the first week of November 2025 in Duluth, Minnesota, and I had just finished installing a snow fence along the edge of my property, preparing for the brutal winter that everyone knew was coming. My name is Xavier Rowland, and I had lived in the Northwood Heights subdivision for 3 years without any major issues. Sure, there were the usual complaints about leaving my trash cans out an extra day or my grass being a quarter inch too tall according to someone's ruler, but nothing that ever escalated beyond a tersely worded letter. I worked as a civil engineer for the city, which meant I understood regulations, codes, and the importance of following rules. I also understood when rules were being applied incorrectly, and I had a feeling I was about to enter that territory. "Mr. Rowland," Patricia called out as I stepped out of my truck. She was in her early 50s, with perfectly styled blonde hair that never seemed to move even in the stiff November wind coming off Lake Superior. She wore a cream-colored pantsuit that looked far too expensive for a Tuesday afternoon in a residential neighborhood. "We need to discuss this eyesore you have erected on your property." I glanced at the snow fence, which was a standard 4-foot-tall orange polymer barrier stretched between metal posts. It ran along the northern edge of my lot, where the wind typically whipped across the open field beyond our subdivision, creating massive snow drifts that had, in previous winters, completely buried my driveway and made it nearly impossible to get to work. Every hardware store in the region sold these fences, and at least a dozen other homes in the area had them up. "It's a snow fence," I said calmly, grabbing my laptop bag from the passenger seat. "Pretty standard for this area, especially with the forecasts calling for a harsh winter." "It violates the HOA covenants," Patricia announced, pulling out a folder that I recognized as one of her infamous violation packets. The woman documented everything like she was building a criminal case. Section 12, Paragraph 4 states that no fencing may be erected without prior board approval, and all fencing must meet aesthetic guidelines that maintain the visual harmony of the neighborhood. I closed my truck door and walked toward her, keeping my expression neutral even though frustration was already building in my chest. That section refers to permanent fencing. This is a seasonal snow management device. It will come down in the spring, just like it does on every farm and rural property in northern Minnesota. The covenant makes no distinction between permanent and temporary structures, Patricia insisted, thrusting a violation notice toward me. "The board convened an emergency meeting this morning after I received complaints from concerned neighbors." "Which neighbors?" I asked, taking the notice. I knew for a fact that my immediate neighbors, the Johnsons on the left and the Martinez family on the right, had both told me they thought the snow fence was a good idea. The Johnsons had even asked where I bought mine. Patricia's lips pressed into a thin line. "That information is confidential. The point is that this fence must come down immediately, or you will face daily fines of $100 until compliance is achieved." I read through the violation notice, my engineering brain automatically picking apart the legal language. The citation referenced Section 12, Paragraph 4, but conveniently ignored Section 3, Paragraph 7, which explicitly allowed for temporary weather-related protective measures. I had read the entire covenant document when I purchased the house, because that was the kind of thorough person I was. "Patricia, I think there has been a misunderstanding of the covenants. Section 3, Paragraph 7 specifically addresses temporary seasonal installations for weather protection. A snow fence falls squarely within that exception. The board interprets the covenants, Mr. Rowland, not individual homeowners. The fence is a violation, and it must be removed within 72 hours. She turned on her heel and walked back toward her Mercedes, which was parked at an angle across my driveway's apron, as if she owned the entire street. I stood there holding the violation notice as the wind picked up, rattling the orange fence material. The forecast called for the first significant snow of the season within the week, potentially 8 to 12 inches. Without the fence, my driveway would become impassable, just like it had been the previous 2 winters before I wised up and invested in proper snow management. That evening, I sat at my kitchen table with the HOA covenant documents spread out in front of me, along with my laptop open to Minnesota state statutes regarding homeowner associations. My cat, a large orange tabby named Diesel, sat on the corner of the table, occasionally batting at my pen when I stopped moving it for too long. The more I read, the more convinced I became that Patricia and the board were wrong. Section 3, Paragraph 7 was crystal clear in its language about temporary seasonal protective installations. The examples it provided included storm shutters, temporary weather barriers, and snow management devices. My fence was textbook compliant. I drafted a formal response to the violation notice, citing the specific covenant language, attaching photos of my fence with measurements proving it met all height and setback requirements, and requesting a formal hearing before the board. I also documented the 12 other homes in the subdivision that had similar snow fences, creating a clear case of selective enforcement if they chose to pursue action against me alone. The response I received 3 days later was not what I expected. Instead of acknowledging the covenant language I had cited or offering a hearing, Patricia sent another notice stating that the board had voted unanimously to uphold the violation, and that fines would begin accruing immediately. Furthermore, the notice stated that Section 3, Paragraph 7 had been superseded by a board resolution passed in 2023 that gave the Architectural Review Committee sole discretion over any external modifications, temporary or permanent. I had never heard of this resolution. I immediately requested a copy of all board resolutions passed since the subdivision's founding, as was my right under Minnesota Statute 515B.3/118, which governed HOA records access. The response came from Patricia's personal email address rather than the official HOA email, and it was terse to the point of hostility. Board resolutions are reviewed annually at the general meeting. The next meeting is in March. Your request is noted but will be processed according to the board's schedule. In the meantime, your fines stand at $300 and continue to accrue. That was when I knew this had moved beyond a simple disagreement about interpreting covenants. This was Patricia wielding power for its own sake, and she had apparently convinced the rest of the board to go along with her crusade against my snow fence. I reached out to Tom Chen, who lived 4 streets over and had served on the board until last year when he rotated off. Tom was a retired attorney who had always struck me as reasonable and fair-minded. We met for coffee at a diner on Miller Trunk Highway, and I brought all my documentation. "Xavier, I am going to be straight with you," Tom said after reviewing my papers. "You are absolutely right on the merits. That snow fence is clearly allowed under the original covenants, but Patricia has turned that board into her personal fiefdom. When I was on it, we had 3 other reasonable people who would push back on her more extreme ideas. Those people have all either moved away or gotten tired of the constant drama, and declined to run for re-election. Now the board is Patricia, her friend Linda Kensington, Linda's husband Mark, and two other people who basically just vote however Patricia tells them to. "What about this 2023 resolution she keeps mentioning?" I asked. Tom frowned. "I was still on the board in 2023, and I don't remember any resolution that gave the Architectural Committee unlimited authority. In fact, we specifically debated that kind of language and voted it down because it was too broad. Let me make some calls." 2 days later, Tom called me back. "Xavier, I think we have a problem." I talked to the other board members who served in 2023, and none of them remember voting on or even discussing the resolution Patricia cited. I requested the board meeting minutes from that period through the management company, and there is no record of any such vote. She made it up. I felt my stomach drop. This was worse than I thought. I cannot prove that without seeing the actual resolution document, but the fact that there is no meeting minute record is highly suspicious. HOA boards are required by state law to keep detailed minutes of all meetings and votes. I spent that evening researching Minnesota HOA law and quickly realized I was in over my head. The statutes were complex, and the case law surrounding covenant enforcement was even more complicated. I needed a lawyer, which was going to cost money I had not budgeted for. But the alternative was paying escalating fines for a completely legal snow fence, or taking it down and dealing with an impassable driveway all winter. I called Janet Morrison, an attorney who specialized in HOA disputes and real estate law. Her office was in downtown Duluth, in one of the old renovated buildings overlooking the harbor. When I met with her the following Monday, she listened to my entire story, reviewed all my documentation, and then leaned back in her chair with an expression that was half amusement and half exasperation. "Mr. Rowland, you have what we call an open and shut case. Your snow fence is clearly permitted under the covenants, and if this resolution Patricia cited does not exist or was not properly voted on and recorded, then the HOA is acting outside its authority. However, I need to warn you that even though you will almost certainly win, this could get expensive and time-consuming. HOAs can be remarkably stubborn, especially when board members take things personally." "What are my options?" I asked. "We can start by demanding a formal hearing, which is your right under the covenants and state law. If they refuse, or if the hearing goes against you, we file suit in district court for declaratory judgment. We would ask the court to rule that your fence is compliant with the covenants and to enjoin the HOA from assessing fines. We would also seek attorney fees and costs under Minnesota Statute 515B.3102, which allows for fee shifting when an HOA acts unreasonably or in bad faith." The mention of attorney fees was important. Janet explained that while she would need a retainer to begin work, if we could prove the HOA was acting unreasonably, the court could order them to pay my legal costs. That made the decision easier. "Let's do it," I said. Janet sent a formal demand letter to the HOA board the next day. It was a masterpiece of legal writing, methodically laying out why the snow fence was permitted, citing specific covenant language and state statutes, and demanding that the violation be rescinded and all fines removed within 10 days. It also requested an immediate hearing before the board and demanded production of the alleged 2023 resolution. The response came not from Patricia, but from a lawyer the HOA had apparently retained, a guy named Russell Vance who practiced in a small firm in West Duluth. His letter was defensive and aggressive in equal measure. He claimed the board had absolute discretion over architectural matters, that my fence violated unspecified aesthetic standards, and that the HOA intended to pursue the matter to the fullest extent. "This is actually good news," Janet told me over the phone after receiving Vance's letter. "His response does not address any of the specific covenant language you cited, and he did not provide the 2023 resolution. That means either it does not exist or they realize it is problematic. Either way, we have them on the defensive." The hearing was scheduled for the first week of December, held in the community room of the subdivision's small clubhouse. By that point, the first major snowstorm had already hit, dumping 14 inches of snow on Duluth over a 24-hour period. My snow fence had performed exactly as designed, creating a drift along its outer edge while leaving my driveway relatively clear and easy to shovel. Meanwhile, several neighbors without snow fences had driveways completely buried under 4-foot drifts that required professional removal services. I arrived at the hearing with Janet, and we found the community room arranged like a courtroom, with the 5 board members sitting at a long table at the front and chairs arranged in rows for observers. To my surprise, at least 20 other homeowners had shown up, including Tom Chen and several of my neighbors. Patricia called the meeting to order with a grave formality that would have been funny if the situation were not so serious. "We are here to address the violation issued to Mr. Xavier Rowland regarding the unauthorized fencing erected on his property in violation of community covenants. Mr. Rowland, you have 15 minutes to present your case." Janet stood and calmly dismantled the HOA's position. She walked through the covenant language, showed photos comparing my fence to others in the neighborhood, and presented the weather data showing the necessity of snow management in our climate. She then addressed the mysterious 2023 resolution. "The HOA has claimed that a board resolution passed in 2023 supersedes the clear language of Section 3, Paragraph 7. However, despite multiple requests, the HOA has failed to produce this resolution or any meeting minutes documenting its passage. Under Minnesota Statute 515B.3116, any rule or resolution must be properly noticed, voted on, and recorded. The HOA's failure to produce documentation strongly suggests this resolution either does not exist or was not properly enacted." Russell Vance, the HOA's attorney, objected. "The board's internal resolutions are not subject to disclosure requirements when they involve architectural standards." Janet did not miss a beat. "That is incorrect. Minnesota Statute 515B.3118 explicitly requires HOAs to maintain and make available all governing documents, which include resolutions. Furthermore, any resolution that purports to override the plain language of recorded covenants must itself be recorded to be enforceable against homeowners who were not on the board at the time of passage." The board members shifted uncomfortably. Linda Kensington, who served as the board secretary, whispered something to Patricia. Mark Kensington, Linda's husband, was looking down at his papers and refusing to make eye contact with anyone. Patricia cleared her throat. "The board will deliberate and issue a decision within 10 business days." "That is unacceptable," Janet said firmly. "Mr. Rowland is being assessed $100 per day in fines for a fence that is clearly permitted under the covenants. Every day of delay causes him financial harm. The board should vote tonight." "The board will issue a decision when it is ready," Patricia snapped, and then she adjourned the meeting despite Janet's protests. As we filed out of the community room, several neighbors approached me to express their support. Carol Martinez, who lived next door with her husband and 3 kids, was particularly vocal. "This is ridiculous, Xavier. Your fence is not bothering anyone and it clearly works. After that last storm, we spent $400 getting our driveway cleared. I wish we had put up a fence like yours. Tom Chen pulled me aside. I counted votes during that hearing. Mark Kensington looked extremely uncomfortable, and so did Susan Perry, one of the other board members. I think they realize Patricia is on shaky legal ground, but they are afraid to vote against her. She has a way of making life miserable for anyone who crosses her. The 10 business days came and went with no decision from the board. Janet filed a motion in Minnesota's 6th Judicial District Court seeking declaratory judgment and injunctive relief. The lawsuit named the Northwood Heights Homeowners Association as the defendant and laid out the entire case in meticulous detail. The filing made the local news. A reporter from the Duluth News-Tribune called me for an interview, and I gave a measured statement about property rights and HOA overreach. The story ran with the headline, "Duluth Man Sues HOA Over Snow Fence Ban." And suddenly, my quiet dispute became a matter of public interest. The publicity did something I had not expected. It emboldened other homeowners who had their own grievances with Patricia and the board. I started receiving emails and phone calls from neighbors sharing their own stories of arbitrary enforcement, excessive fines, and board meetings where dissenting voices were shut down or ignored. One story particularly caught my attention. A woman named Donna Thompson reached out to explain that 2 years earlier, she had been fined repeatedly for parking her work van in her driveway. Donna ran a small cleaning business, and the van was clearly marked with her company logo. Patricia had claimed commercial vehicles were banned under the covenants, even though the covenant language only prohibited commercial vehicles over a certain weight class. Donna's van was well under that limit, but she eventually gave in and paid the fines rather than fight because she could not afford an attorney. I paid almost $2,000 in fines for something that was not even a violation, Donna told me over the phone, her voice shaking with anger. And Patricia knew it was not a violation because other people have work vehicles, but she does not like home businesses in the neighborhood. She told me that to my face. I shared Donna's story with Janet, who added it to our court filings as evidence of a pattern of unreasonable enforcement and selective application of covenants. We also gathered documentation of the other snow fences in the neighborhood that had not received violation notices, building a case for discriminatory enforcement. The HOA's response to our lawsuit was due in mid-December, and when it arrived, it was clear they were doubling down. Russell Vance filed a motion to dismiss, arguing that the court should defer to the board's interpretation of its own covenants and that my lawsuit was premature because I had not exhausted all internal appeals processes. Janet filed a devastating reply brief. She pointed out that the board's refusal to issue a decision after the hearing meant there were no further internal appeals available, and that courts do not defer to HOA board interpretations when those interpretations contradict the plain language of recorded covenants. She also noted that the HOA still had not produced the alleged 2023 resolution. The judge assigned to our case was the Honorable Martin Foster, a veteran of the district court with a reputation for being no-nonsense and efficient. He scheduled a hearing for early January, which meant I would be spending my holidays preparing for court rather than relaxing. Christmas came and went in a blur of legal preparation and growing neighborhood drama. The Northwood Heights community Facebook page, which I rarely checked, had exploded with arguments about my case. There were people defending me and people defending Patricia, and the discourse had gotten ugly enough that the page moderators had to start deleting posts. Patricia herself remained eerily silent in public, but I heard through Tom Chen that she was furious about the lawsuit and had told other board members that she intended to make an example of me to discourage future challenges to board authority. The fines continued to accrue, reaching well over $5,000 by New Year's Day. Janet had filed an emergency motion to stop the fines during the pendency of the lawsuit, but Judge Foster had not yet ruled on it. The hearing in early January was held in the St. Louis County Courthouse, an imposing building in downtown Duluth that always made me feel small when I walked through its doors. Janet met me outside the courtroom, looking confident in a dark suit with her briefcase full of documents and exhibits. "Remember, you do not need to say anything unless the judge asks you a direct question," she reminded me. "This is a legal matter, not a factual dispute. The covenants say what they say." We entered the courtroom and took our seats at the plaintiff's table. Russell Vance arrived with Patricia Henderson and one other board member, a quiet man named David Park, who I had rarely heard speak at HOA meetings. Patricia looked as composed as ever, but I noticed her hands were gripping her purse tightly. Judge Foster took the bench promptly at 9 a.m. and got right to business. "I have reviewed the pleadings and the motions in this matter. Counsel, I am going to be frank with you. This appears to be a straightforward contract interpretation case. The plaintiff has a snow fence that appears to be clearly permitted under Section 3, Paragraph 7 of the Recorded Covenants. The HOA claims it is prohibited under Section 12, Paragraph 4, but that section appears to address permanent fencing, not temporary seasonal installations. Mr. Vance, can you explain to me how the board's interpretation is consistent with the plain language of these provisions?" Vance stood and launched into an argument about the board's broad discretion and the need to maintain neighborhood aesthetics. Judge Foster cut him off. "Counselor, I asked about the plain language of the covenants. Section 3, Paragraph 7 explicitly allows for temporary weather-related protective measures and specifically mentions snow management. How is a snow fence not covered by that provision?" "Your Honor, the board passed a resolution in 2023 that clarified the architectural review process and gave the committee authority over all external modifications. I have read your pleadings, Mr. Vance, and I have seen that this resolution has been referenced multiple times. However, I have not seen the resolution itself. Do you have a copy?" There was a long pause. Vance shuffled through his papers, then conferred quietly with Patricia. Finally, he addressed the court. "Your Honor, the board is unable to locate the original resolution at this time, but board members have testified that such a resolution was passed." Judge Foster's expression hardened. "You are telling me that your entire defense rests on a resolution that you cannot produce?" "Mr. Vance, this is a court of law. I need to see the actual document, properly noticed and voted on according to statutory requirements, not testimony about what board members remember. The HOA's records were partially damaged in a storage issue, Your Honor. We are working to reconstruct them." I saw Janet suppress a smile. This was going even better than she had hoped. Judge Foster was not amused. "How convenient. Miss Morrison, do you have anything to add?" Janet stood. "Your Honor, the plaintiff has made multiple requests for this resolution under Minnesota's HOA Records Access Statutes. The failure to produce it after months of requests suggests it does not exist or was not properly enacted. Furthermore, the plaintiff has documented at least 12 other homes in the subdivision with identical snow fences that have not received violations, suggesting selective and discriminatory enforcement. The HOA is acting outside its authority and causing significant financial harm to my client through daily fines that now exceed $5,000. Judge Foster flipped through the exhibits Janet had filed, which included photos of all the other snow fences and the weather data showing the necessity of snow management. "I have seen enough. I am granting the plaintiff's motion for declaratory judgment. The snow fence installed by Mr. Rowland is clearly permitted under Section 3, Paragraph 7 of the Covenants. The HOA is enjoined from assessing any further fines and must rescind all fines previously assessed. Furthermore, I am granting the plaintiff's motion for attorney fees and costs under Minnesota Statute 515B.3102. The HOA's actions appear to have been unreasonable and not supported by the governing documents." Patricia stood up abruptly. "Your Honor, this is outrageous. The board has the right to maintain standards in our community." Judge Foster fixed her with a stern look. "Madam, you are not a party appearing in this case as an individual. If you wish to address the court, you need to do so through your attorney. However, I will note for the record that HOA boards do not have unlimited authority. They are bound by the covenants they agreed to enforce, and they cannot selectively enforce provisions or create new rules without following proper procedures. This case is a textbook example of board overreach." He banged his gavel. "I will issue a written order within 3 days. This matter is concluded." As we left the courtroom, I felt a weight lift off my shoulders that I had not realized I was carrying. Janet was beaming. That was about as clear a victory as you can get in HOA litigation. Judge Foster was obviously annoyed at their inability to produce the resolution and the selective enforcement. We should expect a very favorable fee award. Behind us, I could hear Patricia arguing with Russell Vance in harsh whispers. I did not look back. The judge's written order arrived 3 days later, and it was even more favorable than I had hoped. In addition to declaring my snow fence compliant and enjoining the HOA from interfering with it, Judge Foster ordered the HOA to pay my attorney fees and costs, which Janet had documented at just over $12,000. The order also included language strongly suggesting that the board review its enforcement practices to ensure they were consistent and non-discriminatory. I thought that would be the end of it, but I underestimated Patricia Henderson's capacity for vindictiveness and poor judgment. 2 weeks after the court order, I received a certified letter from the HOA informing me that I had been selected for a comprehensive property compliance review. The letter, signed by Patricia, stated that an inspector would be visiting my property to document any and all covenant violations, including landscaping issues, exterior maintenance concerns, and any other matters falling under board jurisdiction. I immediately forwarded the letter to Janet, who called me within an hour. "This is retaliation, pure and simple. They are not allowed to do this under Minnesota law. The statute specifically prohibits HOAs from taking adverse action against homeowners who exercise their legal rights to challenge board decisions." "Can we go back to court?" I asked. "Absolutely. This might actually give us grounds for a separate claim for harassment and retaliation. Let me draft a cease and desist letter first, and if they do not back down, we will file a motion for sanctions." Janet's cease and desist letter was blunt and threatening. It pointed out that targeted inspections in retaliation for exercising legal rights violated Minnesota Statute 515B.3102 and could subject individual board members to personal liability, not just the HOA as an entity. That last part was crucial because it meant Patricia and the others could be on the hook personally if they continued down this path. The response came not from Russell Vance, but from a different attorney, a woman named Michelle Harper from a larger firm in Minneapolis. Her letter was apologetic and professional. She informed us that the board had voted to rescind the inspection notice, and that the Northwood Heights HOA would be conducting a comprehensive review of its enforcement policies to ensure compliance with state law and the covenants. Reading between the lines, it was clear the HOA's insurance carrier or management company had gotten involved and told them to back down before they made things worse. Janet confirmed my suspicion when she called. Michelle Harper specializes in representing HOAs, and she is very good. The fact that they brought her in means someone realized Russell Vance was in over his head, and that Patricia was leading them toward more legal liability. This is good news for you. But the drama was not quite over. In late February, I received a notice about an emergency special meeting of the HOA membership to vote on recalling the current board and electing new members. The notice was signed by Tom Chen and 15 other homeowners, representing well over the required threshold to call a special meeting under the covenants. The meeting was scheduled for early March, and I made sure to attend. The community room was packed with homeowners, many of whom I recognized from the neighborhood but had never formally met. The energy in the room was electric and angry. Tom Chen stood at the front and methodically laid out the case for recalling the board. He detailed Patricia's pattern of selective enforcement, the legal fees the HOA had been forced to pay due to her overreach, and the general atmosphere of intimidation she had created. He also revealed something I had not known. The HOA's insurance premiums were going to increase significantly because of the lawsuit, meaning everyone's dues would go up. "This is not about Xavier Rowland's snow fence," Tom said. "This is about a board that has forgotten it exists to serve the community, not to rule over it. We need leadership that will enforce our covenants fairly and reasonably, not use them as weapons against anyone who disagrees with the board." Patricia tried to defend herself, but the mood in the room was hostile. When she claimed she had only been trying to maintain property values, at least a dozen people shouted her down. The vote was not even close. All 5 board members were recalled by margins of more than 70%. A new board was elected on the spot, with Tom Chen as president, Carol Martinez as vice president, and 3 other reasonable people I knew from the neighborhood filling out the remaining positions. As the meeting adjourned, Patricia gathered her things in silence. I watched her leave through the back door, Linda Kensington trailing behind her. I almost felt sorry for her, but then I remembered the $5,000 in fines she had tried to extract from me for a completely legal snow fence. The new board's first official act was to send a formal letter to all homeowners acknowledging the previous board's failures and committing to transparent, fair enforcement of the covenants. They also announced they were conducting an audit of all fines assessed over the previous 3 years to identify other cases of improper enforcement. That audit uncovered a mess. Donna Thompson and at least 6 other homeowners had been improperly fined for violations that were either not violations at all or were selectively enforced. The new board voted to refund those fines, which cost the HOA an additional $8,000. In April, I received a check from the Northwood Heights HOA in the amount of $12,347, representing my attorney fees and costs as ordered by Judge Foster. I promptly wrote a check to Janet Morrison's firm, settling my account with her. "It has been a pleasure working with you, Xavier," Janet told me when I stopped by her office to deliver the check in person. "I wish more of my clients were as organized and reasonable as you were, and I hope you do not have any more HOA troubles." "I think the new board is going to be much better," I said. Tom Chen is a straight shooter, and he actually understands that covenants are supposed to be interpreted reasonably. As spring turned to summer, life in Northwood Heights returned to normal. I took down my snow fence in late April, just as I had always planned to do. My driveway, which had remained clear and accessible all winter thanks to the fence, was in much better shape than those of neighbors who had dealt with repeated plowing and heavy snow removal equipment. The following November, when it came time to put the snow fence back up, I did so without any hesitation. Carol Martinez and 2 other neighbors had also installed snow fences that year, having seen how well mine worked. Nobody from the HOA said a word. I ran into Patricia Henderson one Saturday afternoon at the grocery store on Central Entrance. We made eye contact across the produce section, and for a moment, I thought she might say something. Instead, she turned her cart and walked away. I heard through the neighborhood grapevine that she and her husband were planning to move to Arizona, where presumably she could find a new HOA board to terrorize. Tom Chen did an excellent job as board president, running meetings efficiently and always coming back to the actual covenant language when enforcement questions arose. The neighborhood became noticeably more relaxed, and the Facebook page stopped being a constant source of drama and arguments. One evening in December, almost a year after my court hearing, I was sitting on my front porch watching the snow fall when Tom walked over with 2 beers. "Thought you might want to celebrate," he said, handing me one. "The management company just sent over our insurance renewal. The premiums are actually going down this year because we have not had any legal claims. You know what that means? Everyone's dues are staying flat instead of going up." We sat in comfortable silence for a while, watching the snow accumulate on the street. My snow fence was doing its job, creating a neat drift along the property line while keeping my driveway clear. "You know," Tom said eventually, "what you did was important, not just for yourself but for everyone in this neighborhood. Patricia ran this place like a fiefdom for years, and nobody had the courage or resources to stand up to her. You proved that homeowners have rights and that boards cannot just make up rules on a whim." "I just wanted to keep my driveway clear," I said with a laugh. Maybe that is how it started, but it became about something bigger. A lot of people learned that they do not have to just accept it when authority figures abuse their power. That is worth more than $12,000 in legal fees. He had a point. In the month since the lawsuit, I had received dozens of thank you messages from neighbors, and not just from Northwood Heights. The news coverage had reached people in other HOA communities throughout the Duluth area, and apparently, my case had inspired several other homeowners to push back against unreasonable board actions. The snow continued to fall as we finished our beers. Inside my house, Diesel was probably sleeping on the couch, completely unconcerned with HOA politics or covenant interpretation. Sometimes I envied his simple life, but as I looked at my snow fence standing sentinel against the winter wind, I felt a deep satisfaction. I had stood up for what was right, endured months of stress and uncertainty, and ultimately prevailed. The court had vindicated my position, the HOA had paid my legal fees, and my rights as a homeowner had been firmly reinstated. More importantly, an entire community had been freed from the grip of a board that had forgotten its purpose. The new leadership understood that homeowners associations were meant to maintain property values and provide services, not to micromanage every aspect of residents' lives or settle personal scores through selective enforcement. As winter deepened and the snow continued to pile up across northern Minnesota, my driveway remained clear and accessible, exactly as I had planned. The snow fence that had caused so much controversy was now simply another piece of sensible winter infrastructure, no different from the snow blowers in garages or the bags of ice melt stacked on porches. Tom eventually headed home, and I went inside to warm up. The house was quiet and comfortable, and I felt more at peace than I had in months. The legal battle was over, justice had been served, and life had returned to normal. Sometimes standing up for yourself means enduring a difficult fight, but the alternative, accepting injustice and overreach, is ultimately worse. I had learned that lesson thoroughly, and I knew I would never forget it. The snow fence would go up every November and come down every April for as long as I lived in that house. And if anyone ever questioned it again, I had a court order and a story about standing up to HOA abuse that I could share. But I did not think that would be necessary. The new board understood the covenants, respected homeowner rights, and applied rules fairly and consistently. That was all anyone really wanted from a homeowners association. It should not have required a lawsuit to achieve that basic standard of governance, but sometimes that is what it takes to remind people in authority that their power has limits. I poured myself a bourbon, settled into my favorite chair, and pulled up the weather forecast on my phone. Another storm was coming midweek, potentially the biggest of the season so far. My snow fence was ready, my snow blower was fueled and maintained, and I had plenty of ice melt on hand. Let it snow, I thought. I was prepared, and more importantly, I had the legal right to be prepared in the way that worked best for my property. That right had been tested, challenged, and ultimately confirmed by a court of law. It was a good feeling, knowing that I had fought for principle and won. The $12,000 the HOA paid in legal fees served as a reminder to future boards that homeowners were not powerless, and that courts would enforce covenants according to their actual language, not according to the whims of overzealous board members. Diesel wandered into the room and jumped onto my lap, purring loudly. I scratched behind his ears and looked out the window at the gently falling snow. Life was good, justice had prevailed, and somewhere in the neighborhood, a petty tyrant had been dethroned. That was worth celebrating. Over the next few months, the improvements in neighborhood governance became even more apparent. The new board published a clear enforcement policy that explained exactly how violations would be identified, documented, and addressed. They created an appeals process that was actually fair and transparent, not just a rubber stamp for whatever Patricia had decided. They also discovered that the HOA's finances were in worse shape than anyone realized. Patricia had been approving expenditures without full board votes, including some questionable landscaping contracts with a company owned by Linda Kensington's brother. Nothing clearly criminal, but certainly inappropriate and suggestive of conflicts of interest. The new board hired a forensic accountant to review 3 years of financial records, and while they ultimately decided not to pursue legal action against the former board members, they did implement strict new financial controls and transparency measures. Monthly financial statements were now posted on the HOA website where any homeowner could review them. In May, I attended the annual HOA meeting, which was the first one under the new board's leadership. The contrast with previous meetings was stark. Tom Chen ran through the agenda efficiently, answered questions clearly and completely, and when disagreements arose, he facilitated productive discussion rather than shutting people down. During the open forum portion of the meeting, Donna Thompson stood up and publicly thanked me for fighting the snow fence battle. If Xavier had not had the courage and resources to stand up to the old board, I would still be bitter about the money they took from me unfairly. But the new board reviewed my case and refunded my fines, and that means the world to me. It was not about the money, it was about being treated fairly. Several other homeowners echoed her sentiments. It was humbling and gratifying to hear how my individual fight had created positive change for the entire community. The meeting ended with the new board being formally elected to full terms, running essentially unopposed. Nobody missed the old board, and Patricia Henderson's house went on the market in June. I heard they got a good price for it, and by August, a young family with 2 kids had moved in. They seemed nice, and they did not have any complaints about my snow fence when winter came around again. As I write this, it has been almost 2 full years since the snow fence controversy began. The legal battle seems like ancient history now, though I still keep all the court documents filed away carefully, just in case. You never know when you might need to prove something. The Northwood Heights subdivision is a better place now, governed by reasonable people who understand that their job is to maintain the community, not to rule over it. Property values have actually increased, not because of strict aesthetic enforcement, but because people want to live in a neighborhood where they are treated fairly and with respect. I still see Tom Chen regularly, and we have become good friends. He told me recently that the HOA's legal insurance carrier sent a representative to do training with the board about proper governance and enforcement practices. Apparently, insurers do not like paying out settlements and legal fees any more than homeowners like paying increased premiums, so they are motivated to make sure boards do not engage in the kind of overreach that leads to lawsuits. My snow fence goes up every November like clockwork. It does its job quietly and efficiently, protecting my driveway from the brutal Minnesota winter winds. Nobody complains about it. Nobody questions it, and the HOA sends me a friendly reminder each spring about the date when seasonal installations should be removed. That is how it should have been from the beginning. A simple, common-sense approach to a practical problem without power trips or manufactured controversies. The experience taught me valuable lessons about standing up for yourself, about the importance of knowing your rights, and about how much damage one person with a little bit of authority and a lot of vindictiveness can cause. It also taught me that communities are resilient and that bad leadership can be replaced when people are willing to get involved. I am grateful to Janet Morrison for her excellent legal representation, to Tom Chen for his friendship and leadership, and to all the neighbors who supported me throughout the fight. I am also oddly grateful to Patricia Henderson because her overreach created the catalyst for positive change. Sometimes you need a crisis to realize that things have gotten off track and to find the motivation to fix them. The snow falls every winter in Duluth, often heavily and frequently. That is just the reality of living this far north. But with proper preparation and the right equipment, it is manageable. The same is true of HOA disputes. They can be intimidating and stressful, but with preparation, knowledge of your rights, and good legal counsel, they are manageable too. My advice to anyone facing similar HOA overreach is simple. Document everything, know what your covenants actually say, and do not be afraid to stand up for yourself when you are clearly in the right. HOA boards count on homeowners being too intimidated or too resource-constrained to fight back. When you prove them wrong, it benefits not just you but everyone in the community. The court order hanging in my home office is a reminder of all of this. Judge Foster's clear language declaring my snow fence compliant and ordering the HOA to pay my legal fees represents more than just a legal victory. It represents the principle that rules must be applied fairly, that authority has limits, and that courts will protect homeowners from overreach when necessary. I hope I never have to go through another legal battle with an HOA. But if I do, I will face it with confidence, knowing that the law is on the side of reasonable homeowners who are simply trying to maintain their properties and live their lives. The snow fence stands outside as I finish writing this, ready for another winter of service. It is just a simple orange barrier, but it became a symbol of resistance against arbitrary authority. That is not what I intended when I bought it at the hardware store, but sometimes symbols choose themselves. Life in Northwood Heights is peaceful now, the way suburban life should be. Neighbors wave to each other, kids play in the streets, and the HOA quietly does its job of maintaining common areas and enforcing reasonable standards. Nobody is being targeted for harassment. Nobody is receiving absurd fines, and nobody is living in fear of what violation notice might show up in their mailbox next. That is what victory looks like, and it was worth every moment of stress and every dollar of legal fees. Justice prevailed, rights were vindicated, and a community was freed from petty tyranny. The snow will keep falling, my fence will keep doing its job, and life will continue on its normal course. But I will never forget the winter I had to fight for the simple right to protect my driveway from the elements, or the day a judge reminded an overreaching HOA board that their authority was limited by law and common sense. That is my story, from beginning to end. A story about snow fences and HOA battles, about standing up to injustice and prevailing through persistence and proper legal action. It is a story with a happy ending, which is more than many HOA disputes can claim. And every time I look at that orange fence stretching across my property line, I smile knowing that it represents not just practical winter preparation, but also the principle that homeowners have rights that cannot be trampled by boards drunk on petty power.